7 justices of the United States Supreme Court issued an emergency ruling in the middle of the night on July 24, 2026, and it hit the American legal system like a sledgehammer through plate glass. Let that land for a second. An emergency ruling in the dead of night. 7 justices, crossing ideological lines that this court almost never crosses, came together to issue an order that fundamentally rewrites how power flows in this country. And if you woke up this morning and this was not the lead story on every major network, if it was not screaming at you from every front page, if your feed was still full of celebrity nonsense and political theater instead of this, that silence is not an accident. That silence is a choice made by people who benefit from you not understanding what just happened. This is the Supreme Court's 7-2 emergency ruling on nationwide injunctions, and it is arguably the most consequential legal decision in a generation. Stay with me because by the time we're done here, you are going to understand exactly what changed, why it matters to your life specifically, and why the institutions that are supposed to inform you chose to look the other way. Before we go any further, if you are someone who is tired of having the most important stories in this country buried under the daily noise machine, subscribe right now. Not for the algorithm, not for me, for yourself, because moments like this one get swallowed fast. The outrage cycle moves on, the news cycle pivots, and the constitutional earthquake that happened at 2 a.m. gets reduced to a footnote by Friday. Subscribe, hit the notification bell, and make sure you never miss the stories that actually shape your life. Now let's get into what nationwide injunctions actually are, because Washington has spent decades hoping you never fully understood this particular piece of legal machinery. And once you understand it, once you see it clearly for what it is, you are going to be furious. Not at one party, not at one president, at the entire system that let this go on for as long as it did. A nationwide injunction is, at its core, a court order issued by a single federal judge that stops a law, a regulation, or a presidential executive action from being enforced, not just for the people who brought the lawsuit, not just in that judge's district, but everywhere, across every state, affecting every American, issued by one person in one courthouse, who nobody outside that district ever voted for. That is what we have been living with. And for years, that tool was not being used sparingly or carefully or as a genuine last resort in cases of obvious constitutional crisis. It was being used as a political weapon, wielded with shameless aggression by every faction that had the lawyers, the money, and the strategic patience to figure out which judge in which city would give them the answer they wanted. Think about the scale of what that actually means in practice. You have 330 million people living in this country. You have a federal government with 3 branches specifically designed by the founders to check each other's power. You have a Congress that is supposed to write the laws, a president who is supposed to execute them, courts that are supposed to interpret them in actual cases brought by actual people with actual injuries. And somewhere along the line, gradually, then suddenly, that entire constitutional architecture got quietly bypassed. Because what is the point of winning an election if your opponents can find a single judge in a favorable jurisdiction and freeze everything you ran on before you've had a chance to implement any of it? And what is the point of losing an election gracefully and fighting back through democratic persuasion if you can just lawyer your way to the same outcome without ever having to convince a single additional voter? That is not self-governance. That is litigation as a substitute for democracy. And both parties, let me be absolutely clear about this, both parties played this game without shame and without apology whenever they thought it served their interests. The geographic dimension of this abuse deserves its own conversation because it is one of the most cynical aspects of how this system got corrupted. Legal teams at major advocacy organizations, the ones with millions in funding, the ones with former federal clerks on staff, the ones who went to the right law schools and know exactly how these systems work. They had courthouse geography baked into their litigation strategy, the same way a football team studies game film. You did not just file your lawsuit. You filed it in the right district. You found the judge whose previous rulings, whose judicial philosophy, whose professional history gave you the best odds. Left-wing organizations knew which districts leaned their way. Right-wing organizations knew theirs. And the result was that national policy, affecting every American, regardless of where they lived, was effectively being determined by the accident of which lawyer filed first in which zip code. That is not a legal system. That is a slot machine for people with law degrees. Every major policy fight you can name from the last 2 decades ran through this machinery at some point. Immigration enforcement actions frozen by a single judge in Texas or Hawaii, depending on which administration was acting. Environmental regulations suspended nationwide by a district court in Louisiana. Vaccine mandates blocked across the country by a judge in Missouri. Gun regulations tied up in districts known for particular judicial philosophies. Voting rules frozen and unfrozen by courts in Georgia, Wisconsin, Arizona. It did not matter which side you were on politically. It did not matter whether the underlying policy was wise or foolish, constitutional or overreaching. What mattered was who filed first, where they filed, and whether they got lucky with the draw. This is the system the Supreme Court just declared constitutionally illegitimate. And it is about time, about 2 decades too late, but better now than never. If you are finding this breakdown valuable, if you are someone who wants analysis that actually respects your intelligence instead of talking down to you, drop a comment below and tell me what you think about this ruling. Tell me if you think this is a win, a loss, or something more complicated than either. And share this with someone who needs to hear it, because the conversations that matter don't happen in isolation. They happen when people like you decide that information this important is too consequential to keep to yourself. Now let's talk about what the court actually said, because the ruling itself deserves more than a headline. The legal concept at the center of this decision is what scholars call the scope of injunctive relief. And in plain English, it comes down to one core question. When a federal court sides with the people who brought a lawsuit, how far does that court's authority actually extend? Does the court's order protect only the specific plaintiffs, the specific people or organizations who walked through the courthouse door, hired lawyers, and made their legal arguments? Or does it extend outward to cover every single American who might be similarly situated, whether they asked for that protection or not? For decades, lower federal courts answered that question with breathtaking expansiveness. They routinely issued orders that went far beyond the parties before them, freezing federal policy nationwide on the theory that the harm was broad and the relief needed to match the harm. It sounds logical on the surface. It sounds even compassionate in certain framings. But the Supreme Court, with 7 justices agreeing, which is not a number you see very often on this court, just said that reasoning is constitutionally wrong. The majority's position, as delivered in this emergency order, is grounded in a principle that should not be controversial, but has somehow become revolutionary. Injunctive relief must be proportional to the actual injuries suffered by the actual people who actually brought the actual case. Courts exist to resolve disputes between parties. They do not exist to manufacture national policy outcomes through judicial decree. They do not exist as a parallel legislature where losing coalitions can achieve through litigation what they could not achieve through legislation. The moment a court's order extends beyond making the plaintiffs whole, beyond remedying the specific harm that brought those specific people to court, that court has crossed a line from judicial power into something the Constitution never authorized. That is what 7 justices said, together. In an emergency order that could not wait for the normal briefing schedule, the normal oral argument process, the normal deliberative timeline. This was urgent enough to issue in the middle of the night, which alone tells you everything about how the justices viewed the gravity of what lower courts have been doing. The 2 dissenters, for their part, raised concerns that are worth taking seriously rather than dismissing. Their argument centers on the practical reality that some federal policies cause harms so widespread, so immediate, and so difficult to remedy piecemeal that limiting injunctive relief to named plaintiffs creates a system where millions of people are denied protection simply because they did not happen to be part of the lawsuit. That is not a trivial objection. There are genuine cases where a single plaintiff's victory provides essentially no real-world protection to anyone else in a similar situation, and where the harm continues unabated for everyone outside the courtroom. But the majority's response to that concern is essentially this: Congress exists, the political process exists, class action litigation exists. The answer to broad policy harms is not to transform individual judges into de facto national legislators. The answer is to use the democratic and legal tools that were actually designed for scale. That tension between judicial efficiency and constitutional structure is real, and it is not going away. But 7 justices decided which side of that tension they came down on, and they came down hard. Now let's talk about what actually triggered this ruling, because the mainstream coverage is largely treating this as an abstract legal development that dropped from the sky without context. It did not. This ruling emerged from a specific and intensifying conflict between the federal government and a significant coalition of state governments that had reached a breaking point over what they described as a sustained, deliberate pattern of federal overreach. And we are not talking about fringe actors here. We are not talking about a handful of political outliers making maximalist arguments at the edges of constitutional doctrine. We are talking about governors, attorneys general, and state legislators from across the political and geographic spectrum who went to federal court with a coordinated argument that the executive branch, regardless of which party controlled it, had been using the threat of nationwide injunctions and the reality of favorable judicial forums to implement policies that bypassed state sovereignty in ways the Constitution does not permit. The specific cases that built toward this moment involved a range of policy areas: immigration enforcement, environmental standards, labor regulations, healthcare mandates, and in virtually every one of them, the pattern was the same: federal action, state objection, federal court filing in a favorable jurisdiction, nationwide injunction, policy frozen for months or years while litigation worked its way through appeals. In some cases, the litigation outlasted the administration that issued the original policy, rendering the entire legal battle moot while consuming years of court resources and creating sustained uncertainty that real people or businesses, workers, families had to navigate. By July 2026, that cycle had become so predictable, so exhausting, and so obviously disconnected from any functional conception of governance that the Supreme Court decided it could no longer look away. The emergency posture of this ruling suggests that at least 7 justices concluded that waiting for a fully litigated case to work its way through normal appellate channels was itself a form of institutional negligence. The problem was too entrenched. The distortion of the legal system was too severe. The ruling needed to happen now. Let's get concrete about what this means for ordinary Americans, because legal abstraction only goes so far, and what matters ultimately is how this ruling lands in real lives. The most immediate consequence is straightforward. Executive actions that were previously frozen by nationwide injunctions, issued by single district courts, are no longer automatically blocked on a national basis. Going forward, a plaintiff who wins an injunction in federal court gets relief for themselves and potentially for the class of people they represent. But they do not automatically freeze the policy for 330 million Americans who are not party to the case. That means if the federal government implements a new immigration enforcement policy, a ruling in one district court does not automatically suspend that policy everywhere while appeals proceed. It means if a new environmental regulation is challenged, the challenge has to be litigated in a way that actually encompasses the full scope of who is claiming harm. It means that the easy, fast, geographically targeted judicial veto that both parties have relied on for 2 decades is gone. For some Americans, that is going to feel like a loss, and I want to be honest about that rather than pretending this ruling is costless. If you are someone who has benefited from a nationwide injunction blocking a policy you believe was genuinely harmful, an immigration crackdown, a labor rule rollback, an environmental deregulation, you are right to recognize that the tool that protected you has been significantly constrained. Future challenges to federal overreach will require broader litigation strategies, class action approaches, or congressional action rather than a single favorable filing in a favorable district. That is a real cost, and it falls unevenly on people with fewer legal resources, because the organizations with the biggest litigation budgets are best positioned to adapt to a more complex legal landscape. But here is the other side of that ledger. If you believe that self-governance means something, that elections should have consequences, and that democratic majorities should be able to implement policies without being vetoed by a single unelected judge sitting in a friendly zip code, then this ruling is a restoration of something that had been systematically eroded. Power is moving, at least partially, back toward the elected branches where the Constitution intended it to live. And here is the uncomfortable reality that cuts across every partisan preference. The same tool that progressives used to block Trump immigration orders in 2017 was the same tool that conservatives used to block Biden vaccine mandates in 2021. The same tool that environmental groups used to freeze pipeline approvals was the same tool that energy companies used to freeze emissions regulations. Nobody's hands are clean here. Nobody gets to claim they only supported nationwide injunctions when the cause was righteous, because every side weaponized this tool the moment it served their interests. The Supreme Court just took the weapon away from everybody. And the people who are loudest in their outrage right now are the people who were most recently planning to use it. This brings us to the question that the media is not asking loudly enough, which is, why is this ruling not dominating every broadcast, every front page, every political conversation in America right now? A 7-2 emergency decision from the Supreme Court that changes the fundamental mechanics of how federal policy gets challenged and blocked. That is not a niche legal story. That is a story about the architecture of American power. And yet here we are, with coverage that is cautious, hedged, buried under other noise, and largely stripped of the urgency that the ruling itself demands. I have a theory about why, and it is not flattering to the institutions involved. The media organizations that cover this beat, the legal correspondents, the political journalists, the editors who decide what goes above the fold, many of them have spent their careers operating in a world where nationwide injunctions were a feature, not a bug. They covered them, analyzed them, used them as a metric of political success and failure. The entire ecosystem of political journalism that developed around this tool has a vested interest in treating its curtailment as complicated rather than as the correction of a long-running abuse. Complicated is safe. Complicated does not require taking a position. Complicated allows you to quote both sides and file your story without committing to the obvious conclusion that the system was broken and somebody finally fixed a piece of it. The bureaucracy's quiet panic is equally revealing. Career officials in federal agencies that have spent years either wielding or being blocked by nationwide injunctions are now doing rapid calculations about what this ruling means for their regulatory agendas. The lawyers at major advocacy organizations who built their professional reputations on mastering the geography of favorable jurisdictions are rethinking their entire playbook. The political operatives who treated judicial forum shopping as a standard tactical option are suddenly confronting a world where that option is significantly diminished. None of those people are eager to explain to the public what they have been doing, because explaining it requires admitting that the system they were exploiting was not functioning the way Americans believe their legal system functions. It requires admitting that democratic legitimacy was being regularly bypassed by people with the right law degrees and the right connections and the right knowledge of which courthouse to walk into on a Tuesday morning. Here is what this ruling does not fix, because I refuse to give you a one-sided account of a genuinely complicated moment. It does not fix the underlying policy disputes that drove people to seek nationwide injunctions in the first place. It does not make Congress more functional. It does not create a Senate that is capable of passing comprehensive legislation on immigration, climate, healthcare, or any of the other issues where legislative gridlock pushed activists toward the courts. It does not remove the deep political divisions that made judicial forum shopping so attractive as a strategy. What it does is remove one escape valve from a system that has been under enormous pressure for years. And when you remove an escape valve without addressing the underlying pressure, you have to ask seriously where that pressure goes. Does it push people toward more congressional action, more genuine democratic persuasion, more coalition building at the state level? Or does it push people toward more extreme measures because the moderate judicial tool has been taken away? I do not have a definitive answer to that question. Nobody does yet. But it is the question that serious people should be asking instead of reflexively cheering or reflexively condemning based on which team they think benefits in the short term. What I can tell you with confidence is this. The founders designed a system with 3 branches of government because they understood, with a clarity born from painful historical experience, that concentrated power is the enemy of liberty regardless of who holds it. They designed courts to resolve disputes, not to govern. They designed Congress to legislate, not to be bypassed whenever legislation proved politically difficult. They designed the presidency to execute laws, not to be indefinitely suspended by a single judge, responding to a single lawsuit filed by a single plaintiff in a single favorable city. The system they designed was imperfect, deeply imperfect, as the history of this country demonstrates in ways that should never be minimized. But its imperfections were meant to be addressed through democratic struggle, not through legal shortcuts that hollow out the very principle of self-governance. 7 justices just said, in an emergency order issued in the middle of the night, because the situation was that urgent, that one of those shortcuts has gone too far. They were right to say it. The question now is whether the political system has the maturity and the discipline to respond by doing the harder work that democratic governance actually requires. For every elected official who is responding to this ruling by searching for the next workaround, the next procedural trick, the next jurisdictional exploit, the next way to achieve through clever lawyering what democratic persuasion should require, I have a message. The American people are watching, and they are not as naive as you hope. They understand at some level when they are being governed and when they are being managed. They understand when their votes matter and when they are being circumvented. The anger that has driven the political volatility of the last decade, the sense that the system is rigged, that the rules change depending on who has better lawyers, that ordinary people have no real power regardless of how they vote. That anger is not irrational. It is a rational response to a system that actually was being gamed, openly and repeatedly, by people who had the sophistication to exploit its weaknesses. This ruling does not resolve that anger, but it removes one of its most legitimate justifications. And for every ordinary American who woke up this morning without knowing that last night something significant shifted in the balance of power in this country, that is not your failure. That is the failure of every media organization, every political journalist, every editor, every anchor who decided this story was too complicated or too unsexy or too legally technical to put front and center where it belongs. You deserve better than that. You deserve a media ecosystem that treats you as capable of understanding the mechanisms of your own government. You deserve coverage that does not filter constitutional moments through the question of which team benefits before deciding whether to cover them seriously. You deserve to understand what 7 Supreme Court justices decided at 2 a.m. and why they decided it was urgent enough to not wait until daylight. So here is where I leave you, and I want this to land with the weight it deserves. The Supreme Court's 7-2 emergency ruling on nationwide injunctions is not the end of a story. It is the beginning of a reckoning that this country has been postponing for 20 years. It forces a question that every American, regardless of political affiliation, needs to sit with seriously. What do we actually believe about self-governance? Do we believe that elections should have consequences, even when those consequences produce policies we oppose? Do we believe that the answer to political defeat is democratic engagement and persuasion rather than jurisdictional manipulation? Do we believe that the courts exist to protect rights and resolve disputes, not to serve as a backup legislature for coalitions that lost at the ballot box? If the answer to those questions is yes, then this ruling, whatever its short-term political implications, is a correction in the right direction. If the answer is that we believe in democratic norms only when those norms happen to deliver outcomes we prefer, if we reserve the right to route around the democratic process whenever we think our cause is righteous enough to justify it, then we are not committed to self-governance at all. We are committed to winning. And the difference between those two things is the difference between a republic and something else entirely. This ruling will be fought over, litigated further, and tested against new facts and new cases for years to come. The legal battles are not over. They are entering a new phase. But the principle that 7 justices just affirmed is sound, and it is one that should have been affirmed far sooner. One judge cannot govern a nation of 330 million people. One courthouse in one city cannot determine the fate of federal policy for an entire country. Democratic outcomes deserve democratic responses. That is not a conservative principle or a progressive principle. It is an American principle, and it is one that the highest court in the land just moved to restore. If this conversation mattered to you, if you believe that understanding the actual mechanics of power in this country is more important than the daily theater that passes for political coverage, then subscribe, share this with someone who needs to hear it, and leave a comment telling me what you think. Tell me if you think this ruling helps or hurts the causes you care about. Tell me if you think the media is burying this deliberately or just following the path of least resistance. Tell me what questions you still have, because the conversation around this ruling is just beginning, and your voice in it matters. The institutions that are supposed to keep you informed have failed this story. That failure is on them. What you do with the information now, that part is on you.